Good morning, Mr. Chairman, members of the board. Good morning, Charm TV and those in the room. The September 25th, 2025 proceedings of the Board of Liquor License Commissioners for Baltimore City will now begin. Please take this opportunity to turn off or mute all of your electronics. Don't be the one whose phone goes off in the middle of hearings. Mr. Chair, we have just a couple of preliminary matters before we begin. If you are here for a particular case, please do make sure that you've checked the docket on the exterior of this room to make sure your case is being heard today. And we have a bit of sad news. We are going to say goodbye to Miss Branch, who has been with the board for several years now. Miss Branch, if you could come on up here. Okay. And her immediate, Miss Branch does lots of different things in this office and has for many, many years. She interacts with the attorneys and licensees, communities, folks getting one days. She really is kind of a liaison with everyone outside of this building, and we're very, very grateful for her service. Stacy Russell is her immediate supervisor, and she's going to say a few words as well.
Miss Branch, while we will miss you, we are also excited for you to enjoy this next chapter of your life. I hope that it is filled with rest, joy, and new adventures.
So, Doug tells me you're responsible for the Christmas decoration. Those will be missed sorely unless you come back and do it. But thank you so much for your service. I know that you've always treated everybody kindly and with a smile and given a really fine projection of what this agency is all about. So thank you, and I hope you have a terrific retirement, a healthy one.
And when we're going to have a little celebration after the hearing. We have lots of goodies, and we welcome everyone who wants to stay and enjoy that. And we're going to take a bunch of pictures with Miss Branch and all of you to put in our newsletter. So thank you, Miss Branch.
Thank you.
All right. Okay. All right. The following cases on today's, the following violation cases on today's docket have been postponed and will be heard at a later date. Those are case number 10, Aisha Ali and Myrtle Johnson, The Spot LLC, trading as The Spot 11, 71 through 73 West Hamburg Street. Case number 13, Andrew Wheeler, Locals Only, Baltimore LLC, trading as Locals Only, 25 East Cross Street. And then finally, case number 15, Ramesh Chander Suri, Roshni LLC, trading as Monumental Liquors, 2125 East Monument Street. All right, getting into it. Case 1, Rodolfo Rodriguez and Laura Rodriguez, Sajoma LLC, trading as Sajoma, 1708 Fleet Street. Class BD7 beer, wine, and liquor license request for a hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article, Section 12-2202. Please come forward.
Good morning, Stephen W. Fogelman on behalf of the licensee, Rodolfo Rodriguez.
Good morning, Mr. Fogelman. What's the story here?
Good morning. The story is that he closed Sajoma, a Dominican restaurant on Fleet Street, on or about February 20th, 2025. He had the license under contract to be moved. That contract fell through. He since signed another contract to move the license within the 46th district. And so a transfer application should be forthcoming within 45 days. So we'd ask for the 180 days from August 19th. That'll put us to about February 15th or thereabouts, 2026.
Commissioners have any questions?
No question.
All right, thank you, Mr. Fogelman. On the basis of your written application of August 7 and your proffer this morning, I vote to approve a 180-day hardship extension for this BG7 beer, wine, and liquor license.
Yes, based on material testimony provided, I also vote for a request for hardship extension of 180 days.
Based on your August 7th letter and your proffer made today, I also vote to approve your Request for hardship extension of 180 days of this Class BD7 beer, wine, and liquor license.
Thank you.
No exhibits for the record.
Thomas LaGrange and Kevin J. Stevens, B. Moore Thai LLC, trading as Bodie Corner, 3500 Chestnut Avenue. Class B, beer, wine, and liquor license application to transfer ownership with continuation of outdoor table service. Please come forward.
Yes, good morning. Stephen W. Fogelman on behalf of the applicant and licensee here.
Morning. You want to proffer this?
Yeah, sure. This is 3500 Chestnut Avenue. This is Bodie Corner. It's an existing operation. It's well received in the neighborhood. Both of these cases are a shuffling of deck chairs because we are removing the landlord from the D license at 1444 Light Street. And because we have a B and a D, we had to do some rearranging. Mr. Stevens has been affiliated with this restaurant for quite some time. It's a success. It's an internal change of stock, as your summary explains. And Mr. LaGrange here is the city resident for the purposes of the law. Really, nothing's going to change, except we're going to add Mr. LaGrange to the, Mr. Stevens to the license of this one, right? Yeah. No, tell me. That's right. Yeah, we're removing a licensee and adding Mr. Stevens. So that's the only change, and we appreciate your support. Thank you.
It has a clean record, no violations. Commissioners have any questions?
No question.
All right, thank you, Mr. Fogelman. On the basis then of the materials contained in the application and the proffer this morning, I vote to approve this application to transfer ownership of this Class B beer, wine, and liquor license with continued outdoor table service.
Yes, based on material and testimony provided, I also vote to approve the application to transfer ownership with continuation of outdoor table service.
Based on the application materials and the proffer made today by council, I also vote to approve this application to transfer ownership with continuation of outdoor table service.
Ms. Russell?
No exhibits for the record.
Good luck,
Thank you.
gentlemen.
Appreciate it.
Natnuta, please
tough one.
forgive me. Natnuta Samprasong Stevens and Lei Nu Lei B. All Thai LLC, trading as Bodie Federal Hill, 1444 Light Street. Class D, beer and light wine license, application to transfer ownership. Please come forward.
Thank you. Good morning. Stephen W. Fogelman on behalf of Natnuna Stevens and Lei Nui Lei. Miss Lei is acting as a city resident, and she actually lives above the restaurant in Federal Hill. She had to travel to Myanmar as she has a parent who's very ill, and so she's not able to be here today. Miss Stevens is here. Miss Stevens is married to Mr. Kevin Stevens, who you just met. They both run Bodie Federal Hill and Bodie Corner. And I've not been to the location in Hamden, but I've been to the Federal Hill location. It's a great place, and it's quiet. It serves the community. It's just a D, so it's beer and wine, I believe. And it is very, very compliant business, and they've served the public admirably. This is also a change of stock or a change of licensee in order to get the landlord off the license. It's been on the license for some time, and I helped with that transfer a couple of years ago, but it's past due time for them to come on the license. So I really don't have much to offer beyond that, but they've been a service to the community. Thank you.
Again, they have a clear record, so I ask commissioners if they have any questions.
No question.
All right, Mr. Fogelman, thank you. On the basis then of the materials contained in the application and the proffer this morning, I vote to approve this application to transfer ownership of this Class D beer and light wine license with outdoor table service.
Yes, based on material testimony provided, I also vote to approve the application to transfer ownership and the request for outdoor table service.
Based on the application materials and the proffer made by council, I also vote to approve this application to transfer ownership of this Class D beer and light wine license with outdoor table service.
Ms. Russell?
No exhibits for the record.
Thank you. Good luck, Ms. Stevens.
Thank you.
David Tobash, Soldi Fosa, LLC, trading as The Chasseur, 3326 through 28 Foster Avenue, Class BD7 beer, wine, and liquor license. Violation of Rule 4.071, open containers and illegal possession and consumption of alcoholic beverages on May 2nd, 2025, allowing patrons to drink on the upstairs deck, which is an unlicensed part of the property. Please come forward.
Mr. Fogelman?
Yes, good morning, Your Honor. Stephen W. Fogelman. I have the licensee, Mr. Tobash, to my right. This will be an admission.
Okay, you may proffer.
Thank you. Mr. Tobash is the owner. He also lives a block away. He's very hands-on with this establishment. We had a little situation on May 2nd. We had a brand new manager, Mr. Napier, who's now a pro. He's been around for months. But he did not know that there is a deck on the fourth floor, which is not part of the licensed establishment. And they don't want it licensed because of liability, because it's way up there. And what they normally do is they have wedding parties and people come in and take photos up there with no alcohol. It's got a nice view of the harbor, the Natty Bow building. In this case, this private party went up there with drinks, which is prohibited. Obviously, the manager's been instructed, all employees have been instructed that that can't happen again, both for liability purposes and for liquor board regulations. So that's what we got, and I appreciate your consideration. Thank you.
You want to identify yourselves for the record? Yes, please.
Raise your right hand. Do you swear or affirm under the penalty of perjury that the answers that you give and statements that you make will be truthful,
Were they? They were, okay. All right, commissioners have any questions?
No questions.
No questions.
All right, thank you. On the basis then of the materials contained in the charging documents, the proffer from counsel, which included an admission, I find a violation of Rule 4.07, small 1, open containers, on May 2, 2025. He's had this license for about 11 years and has one prior.
Yeah, that was during COVID. It was a Christmas party or something like that for employees only.
I'd impose a $300 fine and give him 30 days to pay.
Yes, based on material testimony provided. I also agree with the chair's findings. Violation of Rule 4.071, open containers and illegal possession, consumption of alcohol beverages with a fine of $300.
Based on the charging documents, proffer made by counsel. Also, an admission that was made today, also agree that there was a violation of Rule 4.071, open containers and illegal possession and consumption of alcoholic beverages on May 2nd, 2025. I agree with the chair. $300 fine, 30 days to pay.
Thank you.
Medical exhibits for the record. Board Exhibit 1, violation report, Agent Sudhope.
Thank you.
Thank
Good luck.
you.
Chuma, Chiza, MK, and K Inc., trading as Chuma's Discount Liquor and Cuisine, 5142 Park Heights Avenue, Class BD7 Beer, Wine, and Liquor License. Violation of Rule 4.181, alterations on April 2nd, 2025, storing alcohol in an unlicensed part of the establishment without approval. Violation of Rule 4.204B, specific requirements and prohibited activities by license type. Also on April 2nd, 2025, failing to operate the tavern when packaged goods area is open. Violation of Rule 3.092, restroom facilities and health regulations. April 2nd, failing to properly utilize the three-compartment sink. Violation of Rule 4.172, storage on April 2nd, 2025. Storing alcoholic beverages on the floor and not the 6 inches off the floor as required. Please come forward.
Counsel?
Good morning, JU representing the respondent, Mr. Chuma Chiza.
Good morning. Will this be an admission or denial?
It's going to be an admission.
Okay. Would you like to proffer?
Yes, Mr. Chuma did reprimand most of the issues, if not all of it. All the inventory on the floor has been raised up to 6 inches. Inventory on the second floor has been reduced down, and now you have removed all of them to the first floor. First floor, yes. Okay. And then the three-compartment sink is working and operating, and the bar has been operational. And to my understanding, the issue was with the employee.
Yes.
So you no longer have that employee.
Yes, I've had the employee.
Okay, so the bar is fully operational.
Yes.
Thank you.
Have you been sworn? Yes. Okay. You want to identify yourself for the record?
I was back there. Or you'd like to do it here? Let's do it.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
Have you been back to this location since it was violated?
I have.
And is he in compliance now?
He is, although it is still not clean, neat, or tidy. He did indeed elevate the alcohol, the sinks were operational, and the bar was in operation while the liquor store was open.
So he needs somebody to come in and clean, is that what you're saying?
Yes, please.
Okay. Commissioners have any questions?
No questions?
No questions.
All right, thank you. On the basis then of the materials contained in the charging documents, the proffer from counsel and testimony received, I find a violation of Rule 4.181 alterations, violation of Rule 4.20 4 small b, specific requirements of prohibited activities by license type, violation of Rule 3.092, restroom facilities and health regulations, and a violation of Rule 4.172, storage, all on April 2, 2025. I would impose a $150 fine as to each and give him 30 days to pay.
Yes, based on material and testimony provided, I agree with the chair's findings. A violation of Rule 4.181, alterations, $150. Violation of Rule 4.204B, $150. Violation of Rule 3.092, $150. And violation of Rule 4.172, $150.
Based on the charging documents, the proffer made by counsel, admission made, and testimony that was given today, I also find a violation of Rule 4.181 alterations on April 2nd, 2025. Also find a violation of Rule 4.204B, specific requirements for activities by license type. Also find a violation of Rule 3.092, restroom facilities and health regulations, and a violation of Rule 4.172, storage. All were on April 2nd, 2025. I also agree with the chair, $150 fine for each and 30 days to pay.
Ms. Russell?
I call exhibits for the record. Board Exhibit 1, violation report, Inspector Bass.
Thank you. Good luck, sir.
Thank you.
Joyce Young, 316 through 318 Guilford Avenue, LLC, trading as Iconic Assembly Room, 316 through 18 Guilford Avenue, Class B, beer, wine, and liquor license, liquor arena license. Violation of Rule 3.12, general welfare for loud music on June 4th, 2025. Violation of Rule 3.092, restroom facilities and health regulations for violation of Baltimore City Health Code, Section 9-3062, 1 little I on June 4th. Violation of Rule 3.12, general welfare for loud music on June 22nd, 2025. Violation of Rule 3.092, restroom facilities and health regulations on June 22nd, 2025. Violation of Baltimore City Health Code, Section 9-3062, 1 little I. Violation of Rule 3.12, general welfare for loud music on June 29th, 2025. Violation of Rule 3.092, restroom facilities and health regulations for violation of Baltimore City Health Code 9-3062, 1 little I on June 29th. On violation of 3.12, general welfare for loud music on July 19th, 2025. Violation of Rule 3.092, restroom facilities and health regulations on July 19th, 2025, violation of Baltimore City Health Code 9-3062, 1 little I, and violation of Rule 3.12, general welfare for loud music on July 26, 2025, and finally, violation of Rule 3.092, restroom facilities and health regulations for violation of Baltimore City Health Code Section 9-3062, 1 little I on July 26, 2025. Please come forward.
Good morning, Mr. Chairman, members of the board. Peter Previs on behalf of the licensee. With me here today is Ms. Tracy Stafford, who is the manager and operator of the establishment.
Good morning. Will this be an admission or denial?
Mr. Chairman, because we don't agree with the 3.092 violation, it'll be a denial, but we could probably proffer a lot of what's going on. The June 22nd, 29, 7/19, and July 26 are pretty much the same thing.
Okay. So I'm clear. The general welfare you're admitting?
Technically denial, but we're not going to press it, Your Honor.
All right. Well, let's hear from the inspector.
Agent Tutter, Baltimore City Liquor Board. At 9:43 on June 4th, I responded to a 311 complaint for Iconic Assembly Room located at 316 to 18 Guilford Avenue for disturbing the peace, loud music, front door open. In process of responding to that complaint, I received 2 additional 311s that night at 10:21 and 10:23 for the same, for disturbing the peace. I arrived at approximately 10:24 and parked my work vehicle 2 city blocks away on Saratoga Street, approximately 500 feet, where I could still see the establishment and I could hear music clearly coming from the rooftop of the establishment. I proceeded to take a video recording. At approximately 10:34, I made contact with Miss Stacy Trafford and informed her of my findings. Ms. Trafford offered to turn down the music and state that the event would end at 11. I informed her that I would be issuing a violation and left the establishment without further incident. And then whoever has the next one.
I am here.
Just one at a time.
Sure.
Do you have questions for Inspector Tudhope?
Inspector Tudhope, you'd mentioned in the title of the thing about open door. This isn't a case of an open door, is that correct?
No, it just falls under the complaint, what is listed in the complaint.
So the issue is the music coming from the rooftop deck?
The loud music, yes, sir.
Okay, and did you speak to any of the 311 complainants?
I did not. I don't believe they left contact numbers.
Did you do any sound meter readings?
I do not have a sound meter.
Are you aware of an MOU between the establishment and the community?
I believe I know they have an MOU.
Okay, and you understand that under that MOU that the sound can, as it leaves the rooftop deck, can be at 58 decibels?
Like I said, I was over 500 feet away and I could clearly hear the music, so it was past 50 feet.
Does that mean that you are rendering some opinion that the music was louder than 58 decibels at the rooftop?
I do not have a decibel meter. I just go by
You wouldn't know.
disturbing the peace.
And are you also aware that the MOU requires that the establishment have a line of communication and that the community have a line of communication so that the liquor board's not getting called every night?
I was just responding, like I said in my report, I was responding to a 311 call received.
Okay, so you don't know if anybody from the community is
I am not aware if anyone
making
contacted her.
contact with the establishment with regard to
I am not aware of that, no.
turn it down or anything like that. Miss, did you notice any vehicles going by that evening?
I mean, it's a busy street, lots of vehicles, but the music was clearly coming from the establishment.
Okay, have you been there on other occasions when the music has been loud music coming out of cars?
Yeah.
Okay. Was Ms. Stafford cooperative and
Yes.
turned the music down?
She did.
Okay. Now, I understand that you can hear the music, and you've actually charged under a non-commercial section with being able to hear music. Hearing music is not the same with hearing disturbingly loud music. Is that correct?
Sir, I am just an agent. I do not charge. I just write the violations. And like I put in my report, the day I responded, the music was loud, and I issued a violation.
Okay. So just by reason of the fact that you could hear music from a distance does not make it disturbing. Is that right?
To me, it was disturbing the peace
Why?
because I could clearly hear it from over like I put in my report, I could clearly hear the music 500 feet, which was 2 city blocks away.
And how does that make it disturbing?
Well, clearly it's disturbing because the 311s, I received 311 calls that night.
Well, that's begging the question. The question is you. What did you find disturbing?
The music was at an elevated volume that I found was disturbing the peace.
Okay. Thank you. I have no further questions.
Okay. Agent Jordan?
Yes. Good morning. I am here for the incident on June 22nd when I responded to a 311 for loud music. I parked on Saratoga Street, which is approximately 575 feet away, and I verified that on Google Maps. I found when I parked there and I approached the location, the music was excessive. I took a recording of that music, and that's all.
Agent Jordan, were you there the evening that the car with the loud music was blasting?
I don't believe so.
Oh, okay. Miss Stafford thought that you were. Okay. So were you in touch with any of the 311 callers?
They didn't have any contact information.
Okay. Did you meet with somebody at the establishment?
There was people leaving, so I would have been going against the crowd. So I opted to document everything that I saw.
Did you speak with Ms. Stafford?
No.
Did you speak with anybody else from the establishment that evening?
I did not that day.
Okay. And you used the conclusion excessive. Is that because you could hear the music from where you parked your car?
Yeah, because I was so far away from the location, and the music was louder than the traffic on Route 83, which is right above that area. I parked over 500 feet away, and I could hear it, and obviously somebody was complaining from the neighborhood.
So it wasn't your conclusion that the music was excessive. It's because somebody called 311 and you heard music that you determined that the music was exceedingly loud.
In my judgment, it was loud.
Okay. And did you do any decibel reading?
We don't do decibel readings.
Okay. And you're aware of the MOU that they're allowed to have music coming off of that rooftop deck at 58 decibels when it leaves the rooftop deck?
I will take your word for it, but I can't remember every MOU. Sometimes the locations don't have them on hand.
Okay. Thank you. I have no further.
Okay, who had June 29? Have you been sworn?
No, not yet, sir.
And any other agents that are going to be testifying, we might as well swear everyone in.
Yeah, please raise your right hand.
Do you swear or affirm on penalty of perjury that the answers that you give and the statements that you make be the truth, nothing but the truth?
Yes. Good morning. Inspector Zain Nazir, Baltimore City Liquor Board. On June 29th, at approximately 10:12 p.m., while Agent Hine and I were on duty, a 311 complaint was filed for Iconic. We arrived on the scene at approximately 10:50 p.m. Immediately, we parked on the intersection of Pleasant and Guilford, which is approximately 260 feet away, according to Google Maps. And at that intersection, we could clearly hear music that was emanating from the rooftop at Iconic. We then moved further back to the intersection of Pleasant and Holiday, which according to Google Maps is approximately 400 feet away from the rooftop. And at that location as well, we could clearly hear music that was coming from the Iconic rooftop. As we were issuing the violation, the event seemed to have ended around 11 p.m., so we issued the violation and we left without further incident.
Questions?
Inspector Nazir, did you speak with anyone that evening?
I did not.
Okay. You didn't see Ms. Stafford or somebody?
I did not. The event was concluded, so there were massive amounts of people leaving the event at the time. I did not feel it was appropriate to bargain at that time.
Okay. And again, you didn't take any decibel reading?
I do not have any decibel readers.
Okay. And your conclusion that the noise, that the music was too loud was because you could hear it from such a distance?
Yes, because I could hear from over 400 feet away from the establishment.
Okay. Were you downtown this weekend?
No, sir, I was not.
Did you go to the event at War Memorial?
No, sir, I did not.
Okay. All right, thank you. I have no further.
Okay, who had July 19th?
Me as well, sir. Same story on July 19th at approximately 9:30 p.m. while Agent Heiner were on duty. A 311 complaint was filed for Iconic for loud music. We arrived at the scene shortly afterwards and again parked on Pleasant and Guilford, which is over 260 feet away, and we could clearly hear music that was coming from Iconic. And not only music, that night we could hear a DJ as well speaking into a mic. We could hear almost every word the DJ was saying. While we were conducting our investigation, a second 311 complaint was filed by a different complainant for loud music at that location as well. due to repeat offenses and once again, the music just being too loud, we issued a violation and left without further incident.
Questions?
Did you meet with anybody on that evening?
No, I did not, sir.
Did you ask anyone to turn the music down?
No, sir, I did not.
Was the event ending?
Yes, sir.
Okay. So as far as you were concerned, it was abated at that point. You didn't need to contact anybody.
It wasn't abated, it was a violation because the music was too loud.
It wasn't a continuing violation. I got you. Okay. Thank you. I have no further.
All right, July 26th.
On July 26 at approximately 11:26, I received 2 complaints for Iconic. I, myself, and Inspector Jordan responded to the complaint at approximately 11:45. We parked our car 2 city blocks on Saratoga away, 500 feet. We could clearly see the establishment and hear music coming from the rooftop. I took a video recording of that. We moved our car to 300 feet away, and we could still hear the music clearly. We made contact with the security on site and asked them to turn down the music and told them that we'd be issuing a violation. We left the establishment without any further incidents.
Can you play one of the videos?
Yes, we have them.
You know which evening this was?
Yes, sir. I have multiple videos and I have labeled the date of each video.
You were standing?
I cannot speak for June 4th.
I believe this is the, where do I have it? Corner of Saratoga. It was on Saratoga Street, approximately 500 feet away, according to Google Maps.
I'll play the June 22nd video now, sir.
Hold on. And you could tell where the sound was coming from?
Yeah. Yeah, there's also, you can't really see in that music, that's a screen flashing different things on it, and every now and then you can hear a DJ talking as well.
That's fine, thank you. Do you have any questions?
No.
Okay. You want to present testimony?
Sure. I'll call Ms. Stafford.
Has she been sworn?
Were you sworn?
Do you swear or affirm under the penalty of perjury that the answers that you give in the statement say you may be the truth, the whole truth, and nothing but the truth?
I do.
And can you state and spell your name?
Tracy Stafford. Tracy's Tracy, Stafford, Stafford.
Go ahead.
Ms. Stafford, you're the full-time operator?
Yes, I am.
You're there pretty much every day?
Every day.
Okay, so the event on June 4th was a Wednesday night as opposed to a Sunday. Do you recall what that was about?
Yes. It was an event we do once a month. And once I got the complaint, I canceled it. We no longer do the business on a Wednesday. Even though I have the right to be open, I just wanted to be more courteous to my neighbors since they had to go work the next day. So we no longer do their events. We did that once and we canceled it. We don't do them any longer.
Okay, and you turned the music down?
Yeah, we'll always turn the music. I had no idea I even had these violations until today. I didn't until this court case. So no one's spoken to me. This is all foreign to me. Again, no decimal readings presented. No one's talked to me except for maybe one officer, the young lady right there. That's it. So, you know, I'm very frustrated, to be quite honest, because I have an arena liquor license. I went from paying $12,000 to $23,000 in a year, but yet I'm not treated like an arena. I lost business to Power Plant. I canceled another event they complained about. They went to Power Plant, no complaints. The arena plays music loud. The stadium does things loud, but I'm treated differently. You have the waterfront Mickey Pavilion, but yet me paying this amount of money, I'm still being treated like a regular person, and I try to keep them as low as I can, but I'm canceling events. I don't do things throughout the week. I'm very courteous. I try to in between 11 and 12, even though legally I can still do 2 in the morning. I don't know what more I can do other than just closing. I pay over $100,000 in taxes a year. I don't know what to do. So I'm frustrated, and I apologize if I'm coming off wrong, but it's very frustrating to me as a patron or a business person to go through this when I'm paying for an arena license that I really don't get the privilege of using. We had Artscape loud. We had a concert last week loud. No one said anything about that. Why am I being treated? I feel almost targeted. That's all I have to say. Thank you for your time.
Did you entered in the MOU?
Yes, I did.
Have you continue the line of communication?
Yes, I have. I talk to them constantly.
Okay.
Normal arena license.
All right, thank you. I have nothing further unless Ms. Stafford. You have questions?
Did you want to argue, Mr. Previous? You said
Yes, Mr.
I mean, you have this MOU that speaks in decibels, but the statute speaks in terms of sound being 50 feet from the borders of the
I
property.
respectfully disagree that 9206 applies to a commercial establishment.
Actually, this is
9306.
9306.
Okay, this is when somebody's in their car and they're driving around with loud music. It's when they're walking down the street with a boombox. If you were so, the first thing that you would apply would be the decibels, and it's in the MOU. The second thing that you would apply would be 9312 commercial noise, 9312 loudspeakers, outcry 9313. So there, if there's music emanating from a commercial establishment, it says it should not be heard from more than 100 feet from the location, the boundary of the location, or the vehicle.
These were far in excess of 100 feet,
Well,
each one.
I would respectfully disagree with the rationality of this statute, of this ordinance in any event. I mean, just because if I'm yelling at my kids at a football game, they're 30 yards away, and I'm saying, go left, did I violate something? I mean,
You don't have a liquor license when you do it.
right, I understand that, but this isn't applicable to liquor licenses either. It's only made applicable through there. So I respectfully disagree that this statute comes into play. We have an MOU. She's trying to comply with it. It's hard, and she understands. She's entered the MOU that she needs to be a good neighbor. She's in a C5 commercial zone, and because of all the office buildings leaving Baltimore City, you now have apartments crunched into the C5 central business district. The level of allowance of cooperation, it's not what it should be in the middle of Roland Park. So we respectfully disagree and submit.
Commissioners have any questions?
No question.
I have no questions.
All right, thank you. On the basis then of the materials contained in the charging documents, testimony received and the arguments from counsel, I find violations of Rule 3.12 General Welfare and Rule 3.092 Restroom Facilities and Health Regulations on June 4, 2025, a violation of Rule 3.12 General Welfare and 3.092 Restroom Facilities and Health Regulations on June 22, 2025. Violation of Rule 3.12 General Welfare and Rule 3.092 Restroom Facilities and Health Regulations on June 29, 2025, and a violation of Rule 3.12 General Welfare and a violation of Rule 3.092 Restroom Facilities and Health Regulations on July 19, 2025, violation of Rule 3.12 General Welfare, a violation of Rule 3.092 Restroom Facilities and Health Regulations on July 26, 2025. I'm somewhat sympathetic to Ms. Stafford. She's trying to deal with the situation. I think she needs some counseling about the parameters of her license, which are not as great as these arena licenses that she thinks that she has. So, Mr. Previs, I'm sure you can speak to her about that and what she can and cannot do. Apparently, she's been cooperative and has terminated these events at the appropriate time and whatever. Had this license for 3 years. Seems like it's the same problem in the past with this. There are how many here? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 violations. Well, I would impose a $100 fine as to each one and give her 30 days to pay.
Okay. Yes, based on material testimony provided, I also agree with the chair's findings. a violation of Rule 3.12, general welfare with a fine of $100, violation of Rule 3.092, restroom facilities and health regulations, fine $100, violation of Rule 3.12, general welfare, fine $100, violation of Rule 3.092, fine $100, violation of Rule 3.12, general welfare, fine of $100, violation of Rule 3.092, fine $100, violation of Rule 3.12, general welfare, $100, violation of Rule 3.092, $100, violation of Rule 3.12, fine $100, violation of Rule 3.092, fine $100.
Thank you. I also agree with the chair. I believe this licensee is attempting to comply and work with the neighborhood. And although it is a violation, and I know that you're going to talk to her about ways that she can rectify these issues. So I do find a violation of Rule 3.12, general welfare, and a violation of Rule 3.092, restroom facilities and health regulations on June 4th, 2025. Also find a violation of Rule 3.12, general welfare, on June 22nd, 2025, violation of Rule 3.092, restroom facilities regulations on June 22nd, 2025, a violation of Rule 3.12, general welfare, and a violation of Rule 3.092, restroom facilities and health regulations on June 29th, 2025, violation of Rule 3.12, general welfare, and a violation of Rule 3.092, restroom facilities and health regulations on July 19th, 2025, violation of Rule 3.12, general welfare, and a violation of Rule 3.092, restroom facilities and health regulations on July 26, 2025. I agree with the nominal fine of $100 per violation and 30 days of pay.
Ms. Russell?
Exhibits for the record, Board Exhibit 1, violation report, Agent Tudhope, 2 and 3, service request summaries dated 6/4/25, 4, service request summary dated 6/4/25, 5, violation report, Inspector Jordan, 6, photos, 7, service request summary dated 6/22/25, 8, violation report, Inspector Nazir, 9, map, 10, service request report dated 6/29/25, 11, violation report, Agent Tudhope, 12, map, 13, service request summary dated 7/26/25, 14, service request summary dated 7/26/25, 15, violation report, Inspector Nazir, 16, service request summary report dated 7/19/25, and 17, service request report summary dated 7/19/25.
Thank you very much.
Sheldon Gill, Caribbean Dynasty LLC, trading as Caribbean Dynasty, 647 West Pratt Street, Class B, beer, wine, and liquor license, violation of Rule 4.181, alterations on March 31st, 2025, outdoor table service set up without permission from the board, violation of Rule 4.16, illegal conduct, March 31st, outdoor bar set up without permission, violation of Rule 3.081B, sanitation and safety, on March 31st, lit hookahs inside of the establishment in violation of the Clean Indoor Air Act. Please come forward.
Good morning. Are you Mr. Gill, sir?
Yes.
Would you raise your right hand, please?
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
So you're charged with 3 violations of our rules. Do you wish to admit them and explain, or deny them and have a hearing?
I can admit and explain.
Okay. Go ahead, please.
Well, I've owned 2 other restaurants in Maryland, in PG County. I didn't know, as far as Baltimore City, which I've learned now, it's a little bit different than PG County. I didn't need a permit to set up outside tables and an outside bar if it is on my property. So I didn't think it applied. I'm still in the state of Maryland, so I had a mini bar set up, and I had tables and chairs serving my patrons outside.
Okay. Now you understand that our rules are different?
Yes. Well, the event coordinator who saw me at first told me it's an easy permit to apply for. I already applied for it and do have it.
Okay. All right. Thank you. Was he cooperative with you?
Yes, sir.
Okay. Commissioners have any questions?
No questions.
No questions.
All right, thank you. Mr. Gill, on the basis of the materials contained in the charging documents and your proffer, which included an admission, I find a violation of Rule 4.181, alterations, violation of Rule 4.16, illegal conduct, and violation of Rule 3.081B, sanitation and safety, all on March 31, 2025. I'd impose a $50 fine as to each and give you 30 days to pay.
Yes, based on material and testimony provided, I agree, also agree with the chair's findings, violation of Rule 4.181, alterations of $50, violation of Rule 4.16, illegal conduct, fine of $50, violation of Rule 3.081B, sanitation safety, fine $50.
Based on the charging documents and testimony that was given today, we had the admission, also see that there was a violation of Rule 4.181, alterations, a violation of Rule 4.16, illegal conduct, and a violation of Rule 3.081B, sanitation and safety, $50 fine, 30 days to pay on each of those.
Ms. Russell?
Like exhibits for the record, violation report, exhibit number 1, violation report, Inspector Bass. Exhibit number 2 through 9, photos.
Thank you. Good luck, Mr. Gill.
All right, thank you.
Zanting, Charles Cow, and Jason Jose Acevedo, Rosario, Castle Seafood Inc., trading as Castle Seafood Restaurant, 3720 Poche Street, Class B, Beer 1 liquor license. Violation of Rule 3.12, general welfare, on August 11th, 2025, loud music. On August 11th, violation of Rule 3.092, restroom facilities and health regulations. On August 11th, 2025, violation of Baltimore City Health Code, Section 9-3062, 1 little I. Violation of Rule 3.12, general welfare, on August 23rd, 2025, loud music. Violation of Rule 3.092, restroom facilities and health regulation, also on August 23rd, 2025, violation of Baltimore City Health Code, Section 9-3062, 1 little I. Violation of Rule 4.16, illegal conduct, on August 23rd, 2025. Outdoor patrons standing instead of being seated and served at outdoor tables as required by BMZA Resolutions Number 240-04. Please come forward.
Good morning, sir. What's your name?
Good morning. My name is Robert Walston.
Robert, what's your last name, sir?
Walston.
Austin?
Walston.
Walston.
Yeah.
Could you raise your right hand, please?
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
Is your last name spelled W-A-L-S-T-O-N?
Yes.
So, Mr. Walston, how are you related to these licensees?
I'm the management of the company.
You manage this operation? Okay. So they are charged with several violations on August 11 and on August 22, 23. Do you wish to admit and explain those or to deny them and have a hearing?
I'm trying to get a postponement to get representation.
Oh, well, okay. You could have tried that beforehand, but that's fine. They want to get representation. When's our next hearing?
October 9th.
We do that?
Yes, sir.
All right, we'll continue the case to our October 9 docket. Give you a chance to retain counsel, okay?
Okay. That's it.
All right, thank you.
All right, thank you.
Sean Connor, ISK LLC, trading as CNC Lounge, 4923 Reisterstown Road, Class BD7 beer, wine, and liquor license, violation of Rule 4.052, prohibited hours, on July 22nd, 2025, open and operating after 10 o'clock p.m. Violation of Rule 4.071, open containers and legal possession and consumption of alcoholic beverages, on July 22nd, 2025, allowing patrons to drink outside, which is an unlicensed part of the property. Please come forward.
For the record, Melvin Jaconescu, representing the licensee.
Good morning. Do you admit or deny, Mr.
We don't contest the facts as they're written there. We do have an argument regarding the first one about being open after the prohibited hours, because apparently the paperwork that we were given shows the place was closed, but people were outside in the backyard at some tables.
Let me hear from the inspector, and then we'll come back.
Agent Perez, Baltimore City Liquor Board. On July 22nd, approximately 10:16 p.m., myself and Agent Hope responded to the location to make exterior observation to determine if they were operating outside of the restricted hours. Our initial observations were that there were approximately 10 patrons on the outdoor patio after 10 p.m., as prior stated. These patrons were observed actively consuming alcoholic beverage. Upon further investigation, we entered the patio through a patio gate and verified that these patrons were consuming beer of different kinds and alcoholic mixed beverage. We proceeded to the interior of the establishment where we found 3 staff members that were cleaning and removing trash from the premises. We made contact with Mr. Curtis Connor and advised him that he was in violation of the 10 p.m. restriction. And also, we advised him that he was not approved for outdoor table service. Mr. Connor was directed to discontinue the outdoor patio until approval was obtained. We left the establishment without any further issues.
Did you have any questions?
Were any sales inside the establishment after 10 o'clock?
I did not observe any sales inside the establishment.
The fact, when the pictures you have, the place was cleaned up and all the chairs were up.
That's correct.
So your observation has to do with the outside area behind the place. Is that correct?
That's correct.
And there was an area there where some people sitting down at some tables and chairs and having some beverage. Is that correct?
Yes.
Did you find out who they were at all? Were they related?
We were told they were family members. I advised Mr. Connor that no one should be on premises consuming alcoholic beverage after 10 p.m.
That's not a licensed premises.
It's not.
Okay. That's the argument is with regard to the first charge, there was no sales or consumption inside. Second, what was transpiring outside was not on a licensed premises.
Commissioners have questions?
No questions.
No questions.
All right, thank you. On the basis then of the materials contained in the charging documents and the testimony received, I would dismiss the violation of Rule 4.052, but I would find a violation of Rule 4.071, and I would impose a $250 fine and give them 30 days to pay.
Yes, based on material and testimony provided, I also agree with the chair's findings of dismissed violation of Rule 4.052, prohibited hours, and also violation of Rule 4.071, open containers and illegal possession and consumption of alcoholic beverages with a $250 fine.
You want to say something about that? It wasn't alcohol.
I'm sorry, yes.
Do you swear or affirm on the penalty of perjury that the answers that you give, the statements that you make, will be the truth, the whole truth, and nothing but the truth? And are you Mr. Sean Connor?
Curtis.
I'm sorry, what's the first name?
Curtis.
Purvis. Okay, thank you.
Sir, you may speak, but it's too late. We've already made our findings, but go ahead.
It wasn't even alcohol, it was liquid IV. So what they're saying.
Liquid what?
Liquid IV. Liquid IV for people that actually get finished drinking hot things. So colorful, ringy, that's what it was. They're making an assumption of something that wasn't true.
I understand. Okay.
Based on the application material, on the charging documents, testimony that was given today, I dismissed the first violation of Rule 4.052, prohibited hours. And as I appreciate what you said, I believe the case was closed by the time we were making our decision. Violation of Rule 4.071, open containers and illegal possession and consumption of alcoholic beverages. On July 22nd, 2025, I find a violation of that rule, $200 fine, and you have 30 days to pay that. $250 fine, yes.
Okay. Ms. Russell?
I call exhibits for the record. Board Exhibit 1, violation report, Agent Perez, 2 through 3, photos.
Okay, thank you.
Jin Suk Moon, River Moon, Inc., trading as G&T Liquor, 2048 Wilkins Avenue, Class A, beer, wine, and liquor license, violation of Rule 4.052, prohibited hours, on July 17, 2025, open and operating before 10 a.m. Please come forward.
Good morning. Are you Ms. Munn? How do you say your name?
Moon, M-U-N.
Okay. Would you raise your right hand, please?
Do you swear or affirm on the penalty of perjury that the answers that you give and the statements that And if you can keep your voice up.
Ma'am, you're charged with this violation on July 17th. Do you wish to admit and explain or deny and have a hearing?
Admit it.
Okay. Do you want to tell us what happened?
Yeah, admit it that I opened the store a little early.
Okay, I'm sorry, I can't hear you. sir.
Yeah, I opened the store a little early because I need to fix the alarm system and also 3-door cooler, the temperature went down. And then man came in, he checked the lottery ticket and took some cans of soda from vending machine and he just left. I thought it would be okay as long as I didn't sell alcohol. But from now on, even if there are any circumstances at the store, I make sure that no customer come enter before 10 o'clock.
So you're saying that it wasn't alcohol that they took away?
It wasn't alcohol.
Did you observe what they took away?
It was a item in a black plastic bag, and when I went in and I spoke to the licensee, she apologized for selling alcohol. We spoke about alcohol.
I didn't apologize. I explained why I'm open a little bit early today, and I didn't sell alcohol. I didn't sell alcohol. I said that.
Well, that's a conversation we had inside. If she had said it was another item like soda, we wouldn't have issued the violation.
All right. Anything further, Ms. Moon? Is there anything else you want to say?
No.
Commissioners have questions?
No question.
No questions.
All right, thank you. On the basis of the materials contained in the charging document, the proffer from Ms. Moon and her admission, as well as the testimony received, I find a violation of Rule 4.052, prohibited hours on July 17, 2025, and impose a $1,000 fine. Give her 30 days to pay.
How much was the fine?
$1,000.
1,000. Okay. Yes, based on material testimony provided, I agree with the chair's findings of violation of Rule 4.052, prohibit hours with a fine of $1,000.
Based on the charging documents, testimony given today, and the admission that was made by the licensee, I do find a violation of Rule 4.052, prohibited hours, $1,000, 30 days.
Ms. Russell?
My exhibits for the record, Board Exhibit 1, violation report, Inspector Jordan. This exhibits 2 through 3, photos.
Thank you.
Group Sandu Bar and Discount Liquors, Inc., trading as J&J Bar and Liquors, 1801 Ramsey Street, Class BD7 beer, wine, and liquor license. Violation of Rule 4.052, prohibited hours on July 17, 2025, open and operating before 10 a.m. Please come forward.
Do we have service on the licensee?
They did, sir. I spoke with the licensee's father. Actually, he said that the licensee would be out of town, but he would be coming to admit guilt.
But they were served.
Yes, sir.
Okay, well, let's proceed.
Agent Tuttle, Baltimore City Liquor Board. On July 17th at approximately 9:54, myself and Inspector Jordan began observations at the outside of J&J Bar located at 1801 Ramsey. Upon our arrival, we observed the front door open and we observed multiple patrons entering and exiting the establishment. At approximately 9:57, we entered the establishment and we observed someone being sold alcoholic beverages. We made contact with the employee identified as Prince and informed him that we observed him being open and operating before 10. The employee then contacted the licensee, Inspector Jordan informed him that he would be receiving a violation for being open before 10 a.m. We left the establishment without any further incident.
Commissioners have any questions?
No questions.
No questions.
All right, thank you. On the basis of the materials contained in the charging documents and the testimony received, I find a violation of Rule 4.052, prohibited hours on July 17, 2025, impose a $1,000 fine and give them 30 days to pay.
Yes, based on material testimony provided, I also agree with the chair's findings, violation of Rule 4.052, prohibited hours with a fine of $1,000.
Based on the charging documents, testimony that was given today, I also found a violation of Rule 4.052, prohibited hours, on July 17, 2025, $1,000 fee, 30 days to pay.
Ms. Russell?
Exhibits for the record. Board Exhibit number 1, violation report, Agents at Hope.
Max Dalton and Justin Janney, Ultra Lounge LLC, trading as Mirage, 401 West Baltimore Street, Class BD7, beer, wine, and liquor license. Violation of Rule 3.081B, sanitation and safety. On July 25th, 2025, lit hookahs and patron smoking cigarettes inside the establishment in violation of the Clean Indoor Air Act. Violation of Rule 3.0811B, sanitation and safety. On July 25th, 2025, a hole in the floor in the bar area. Violation of Rule 3.092, restroom facilities and health regulations. On July 25th, 2025, failure to maintain the establishment in a sanitary condition. Violation of Rule 3.011, ownership and operation. On July 2025, failure to disclose financial interest of Desalin Negusi. Violation of Rule 3.033, records. On July 25th, 2025, failure to provide employee records. And finally, violation of Rule 3.13, bottle service. On July 25th, 2025, patrons were found drinking directly from the bottle. Please come forward.
For the record, Melvin J. Cadency, representing the licensee.
Mr. Cadency, going to be admission or denial?
There'll be an admission with explanations.
Okay, go ahead.
In this particular case, the particular person that is there has a management agreement. They didn't have a management agreement available on the date the management agreement was executed on March the 1st, 2023. You can provide a copy of that to the liquor board. The actual licensee owner, Mr. Dalton, is here behind me. The situation with regard to them cleaning up the restrooms and the ice machine and all that was taken care of. The floor's been repaired. They were closed for a period of 5 days, so they had a substantial penalty from the health department. They have, in fact, indicated that they're, and you hear me say it all the time, no hookah. I'll do it one more time. No hookah for the people at home. He has since gone around, put up, if you look, I'll give you signs all over the place, no vaping, no hookah. He has the employees' records. He didn't have them at the time. I have copies here. He takes driver's licenses. This question within Social Security. They'll be available on the premises at all times. With regard to that, with regard to the drinking out of the bottle, that was something that got out of hand. He has security, 2 or 3 people walking around. He will not let people drink directly from a bottle. If they do, they'll be taken from them, and they will be evicted from the premises. The time that they were closed, the had a substantial financial hardship. Meantime, they've repaired. I've got pictures here if the board would like to see them, where the restrooms are taken care of, the ice machine was taken care of, the floor's been taken care of, no smoking, no vaping is around. And I'm not so sure that it's a phenomenon that you don't see all over the city, but it's not permitted. He's not going to permit it. He has employee records, he has a management agreement, and the actual licensee is here. I don't think you're going to see that kind of problem. It's not the kind of problem like in some of the other cases where you see they have a problem with neighborhoods complaining.
Agent Perez, have you been there since?
I have not.
When you were there, were they cooperative with you?
Yes, all the time.
Okay. And all these things have occurred since July that you were talking about?
They've been all repaired and taken care of. The management agreement was signed last year. It just wasn't available along with the employee records. I said, you have to have them on the premises if somebody wants to go ahead and look at them. Just didn't have them. Now they'll be available on the premises along with the management agreement. If the board wants, I'll submit a copy of the management agreement to the board for their records.
You may, okay. Commissioners have questions?
No questions.
No questions.
All right, thank you. On the basis of the materials contained in the charging documents and the proffer from counsel and testimony received, but the proffer included admissions, and I find a violation of Rule 3.081B, sanitation and safety, violation of Rule 3.081B, sanitation and safety, a violation of Rule 3.092, restroom facilities and health regulations, violation of Rule 3.011, ownership and operation, violation of Rule 3.033, records, a violation of 3.13 bottle service, all occurring on July 25, 2025. I'd impose a $50 fine as to each and give them 30 days to pay.
Yes, based on materials testimony provided, I also agree with the chair's findings of violation of Rule 3.081B, sanitation safety, with a fine of $50. Violation of Rule 3.081B, sanitation and safety, $50. Violation of Rule 3.092, restroom facilities and health regulations, $50 fine. Violation of Rule 3.011, ownership and operation, fine of $50. Violation of Rule 3.033, records, fine $50. And violation of Rule 3.13, bottle service, fine $50.
Based on the charging documents, testimony given today, proffer made by counsel, also find a violation of Rule 3.081B, sanitation and safety, violation of Rule 3.081B, sanitation and safety, violation of Rule 3.092, restroom facilities and health regulations, violation of Rule 3.011, ownership and operation, violation of Rule 3.033, records, violation of Rule 3.13, bottle service. All of those happened on July 25th of 2025, $50 fine for each and 30 days of pay.
Ms. Russell?
I call exhibits for the record. Board Exhibit number 1, violation report, Agent Perez, 2 through 8 photos.
Okay, thank you.
Bijou, Penland, Blanca, Pescara, New Ecstasy Bar and Restaurant LLC, trading as My Cousin's Place. 3925 through 27 East Lombard Street. Class BD7 beer, wine, and liquor license. Violation of Rule 4.052, prohibited hours. On July 20th, 2025, open and operating after 2 a.m. Violation of Rule 3.02A, cooperation. On July 2025, displaying combative behavior and yelling obscenities at Liquor Board staff. Please come forward.
For the record, Melvin J. Konetsky, representing the licensee.
Morning. Admissions or denial?
Be an admission and with explanation.
Go ahead, please.
In this particular case, as you probably know, this place has had a lot of problems with having fires, closed, got reopened. They've been having a situation with a couple other places that are in the same area, real close to them. There's a lounge right down the street, the old Bud Polino's place, and so forth. And a lot of places try to compete with each other, which is not fair. However, I talked to Ms. Pesquera and indicated she has 3 security people, and that people have to be completely off the premises. Apparently on that night, one of the security people, and I read the report, took it on himself to let people stay in there and let them in. And that's what the argument was about between her, the person who was the DJ, and so forth. He has since been terminated. They will now have last call about 1:20, 1:25, and get everybody out of the place by 1:45. I think, and make sure that the security people follow that, and there won't be a problem in the future. And they'd have to, the cooperation has to be with the members of the liquor board. But the arguments were more internal among themselves while the board was there.
Did you have anything to add?
She was very cooperative. Mr. Nero, on the other hand, was not cooperative. He was actually physically having to be held back from the inspectors, and he was shouting profanities at us in Spanish. I could not understand, but my agent and inspector informed me that there were some choice words being said to us.
I don't think there's any, that was not with the licensee, but there was an employee of hers who had an argument with security. She's responsible for it. I'm not trying to say that they're not, but that's since been rectified in this case.
Okay. Commissioners have any questions?
No questions.
No questions.
All right, thank you. On the basis of the materials contained in the charging documents, the proffer from counsel, including the admission and the testimony received, I find a violation of Rule 4.052, prohibited hours, and a violation of Rule 3.02A, cooperation, on July 20, 2025. As to the first, I impose a $1,000 fine. As to the second, I impose a $500 fine, and I give them 30 days to pay.
Yes, based on material testimony provided, I also agree with the chair's findings of violation of Rule 4.052, prohibited hours, with a fine of $1,000, and violation of Rule 3.02A, cooperation, with a fine of $500.
Based on the charging documents proffered made by counsel and testimony heard today, I also agree that there was a violation of Rule 4.052, prohibited hours, and violation of Rule 3.02A, cooperation on July 20th, 2025, $1,000 fine for the first violation, 4.052, and a $500 fine for the second violation, 3.02A, 30 days of pay.
Ms. Russell?
Exhibits for the record, Board Exhibit 1, Violation Report, Agent Tudhope, 2 through 4, photos.
Thank you.
Soon Young Lee and Frank B. Sanders, Nori, Inc., trading as Pops Liquor and Grocery, 2320 Wilkins Avenue. Class A beer, wine, and liquor license violation of Rule 4.052, prohibited hours, on July 15, 2025, open and operating before 10 a.m. Please come forward.
Good morning. Would you folks raise your right hands, please?
You swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth. And you're Mr. Sanders and Ms. Young Lee. Thank you.
Okay. Ms. Lee, you've been charged with this violation. Do you want to admit it or deny it?
Admit it.
Okay. You want to tell us what happened then on July 15th?
Well, my husband, I wasn't there. My husband told me a guy who hired to dump the trash for him, I think accidentally leave the door open, and the customer came, and my husband didn't realize it's not, 10 o'clock yet.
Okay. Agent Perez, anything you want to add?
The only thing I would add is that the operator in that case, Mr. Lee, stated that he decided to open earlier that day, as opposed to the testimony from the licensee.
Okay. Commissioners have any questions?
No questions.
No questions.
Thank you. On the basis then of the materials contained in the charging documents and the proffer from Ms. Lee, as well as the testimony received, I find a violation of Rule 4.052, prohibited hours, on July 15, 2025, and impose a $1,000 fine and give her 30 days to pay.
Yes, based on material and testimony provided. I also agree with the chair's findings of violation of Rule 4.052, prohibited hours, with a fine of $1,000.
Based on the charging documents, the admission was made today. In the testimony that was given, I find a violation of Rule 4.052, prohibited hours, on July 15, 2025, $1,000 fine, 30 days pay.
Good. Ms. Russell?
Exhibits for the record, Board Exhibit 1, Violation Report, Agent Perez.
Thank you, Ms. Lee.
Natasha Burgess, L. Burgess LLC, trading as Rosie Sports Bar, 482 South Benelo Street. Class BD7 beer, wine, and liquor license violation of Rule 4.052, prohibited hours, on July 19, 2025, open and operating after 10 p.m. Violation of Rule 4.071, open containers and illegal possession and consumption of alcoholic beverages, on July 19, 2025, allowing patrons to drink outside, which is an unlicensed part of the property. Please come forward.
Abraham Hurd on behalf of the licensees. We'd be admitting to the 405-2 violation and denying to the 407-1 violation. We'll probably move to dismiss after evidence is presented.
Okay. Agent Perez, do you want to discuss the open containers issue?
Yes, Chairman. After we made contact with the operator that night, the music was shut off and patrons began to leave the establishment. That's when we observed, as you can see on the screen, a gentleman walk out with a drink on his hand.
I'm sorry, how many people did you see leave?
There were approximately 45 people altogether between the exterior, patio, and indoors.
And how many of them, I'm sorry, but 45 people had open containers? Or
No.
How many?
I only observed one person walking out.
One person, okay. Did you have questions then?
Was it a beer can or like a beer bottle?
It appeared to be an alcoholic mixed beverage on a clear plastic cup.
It was a plastic cup?
Yes, sir.
Did you smell the cup?
I did not.
Did you see someone mix a drink and pour it into the cup?
I didn't.
So there's no evidence other than he was leaving the bar as you told him to?
just like the other 44 patrons that were in the establishment has similar drinks on their hands. That was my assumption.
But nothing verifies that all of those drinks were alcohol or none of them were alcohol?
No.
We would move to dismiss that charge at this time.
Commissioners have any questions?
No question.
No question.
And if I would just may add very briefly before we make the final decision, I've spoken to the client about this location. It is a BD7. My understanding is the hours in those areas are restricted to 10 p.m. We've had a discussion about possibly shifting to a B license. They do serve food. We think that'll end up serving them better. They are aware that they cannot be open after 10 until that change is made, and we will proceed forward at that time.
Thank you. On the basis of the materials contained in the charging documents, the proffer from counsel, including the admission of the Rule 4.052 violation, I find a violation of Rule 4.052 on July 19, 2025. I'll dismiss the other violation and impose a $1,000 fine and give them 30 days to pay.
One is dismissed, right?
4.071 is dismissed.
Violation of Rule 4.052, prohibited hours, is dismissed. And violation of Rule 4.071, open containers and illegal possession of consumption of alcoholic beverages, $1,000.
No. It's the other way around.
It's the other way around?
Yeah.
Okay.
What decision?
Right.
But it's the prohibited hours that carry the $1,000 fine.
Violation of Rule 4.052, prohibited hours, fining $1,000. Violation of Rule 4.071, open containers and illegal possession and consumption of alcoholic beverages, was dismissed.
Based on the charging documents proper made by counsel, testimony that we received today, I do find a violation of Rule 4.052, prohibited hours on July 19, 2025, $1,000 fine, and I do agree to dismiss the Rule 4.071 in containers under possession.
Ms. Russell?
Exhibits for the record, Board Exhibit 1, violation report, Agent Perez, 2 through 3, photos.
Thank you, Commissioners. May I be excused?
Randolph Smith, Goldie's Seafood Bar and Grill, LLC, trading as Goldie's Seafood Bar and Grill, 2112 Fleet Street, Class B, beer, wine, and liquor license. Violation of Rule 3.082, sanitation and safety, on June 30th, 2025, overflowing trash cans. Violation of Rule 3.082, sanitation and safety, on July 8th, 2025, excessive trash and overflowing trash cans. Violation of Rule 3.02A, cooperation on July 18, 2025, pushing a liquor board staff member. Violation of Rule 3.12, general welfare, on July 18, 2025, threatening a complainant in front of liquor board staff. And finally, violation of Rule 3.081D, sanitation and safety, on July 18, 2025, not adhering to the outdoor table service limitation of only 12 patrons to be seated outside. Please come forward.
For the record, Melvin J. Konecki, representing the licensee.
Admissions or denial,
There'll
Mr.
be an admission with explanation.
Okay, go ahead.
In this particular case, I know it sounds very bad, but there was a problem with regard to the trash there. I'll get to the last one. In the meantime, what Mr. Smith has done, he has added more trash cans on the side. Now has 5 trash cans, plus he takes the trash himself that's left over to the dump. He has made sure his doors are all closed now. They're not left open. He's taken the outdoor table service and discontinuing it temporarily until he can get a fine handle on how that can be handled. And one issue that is very troubling, I know, to everybody here, is that he's having an ongoing dialogue or discussion with a next-door neighbor, Mr. David, and he was very upset because apparently there were maybe 20 or 30 911 calls, one after another, and he tried to resolve it, and it didn't get resolved, and they got into a heated discussion with him. Add to this, which was the one thing that really, I think, pushed things over the edge, his brother was murdered on a few days before. Not only was he murdered, but his entire family was threatened by the perpetrator. in the case. Several days later, they were able to actually get the person who murdered his brother, and his whole family came down basically to have, or to, as a celebration of a life. I don't have to tell the board, what's going on in society today with people being murdered. Every day you're reading the paper, it's getting completely out of hand. It doesn't strike home until it happens to you and one of your family. In this case, it did, and it struck him. He indicates that he was not justified in having that argument with Mr. David, was not justified in trying to rush through and one of the inspectors, and he's going to apologize. In fact, he had sent a letter to the board. I don't know if you have in the file. I'll give you extra copies. Does the board have his letter?
I think we do.
Well, I'll give you extra copies just so I have them here. And also, Mr. David next door has since patched up things with him and said that he realizes the situation and he accepts his apology from that point of view. This is the very end where Mr. David says, I clearly understand, and he's going to look forward to working. Here's the letter we sent. Mr. Smith said to the board.
That's right. They'll all be received.
And he's worked very hard to try to establish a nice restaurant at that location. And regarding, the food operation and so forth, he's getting very good reviews. In fact, he has his chef here with him, has very good crab cakes and has seafood, and he's been in business everywhere else. I would like to think the board would take, and he wants to address the board on this too, take into consideration that event that sort of pushed him over the edge, which was really called for. I guess we all know who Shakespeare is, right? And he said the quality of mercy is not strained. And this is the kind of case I think reaches out for that in this case. I think it just was a combination of things that happened that probably shouldn't, because nobody deserves to have anybody in their family murdered or threatened in the case. But once that happens and you deal with the circumstances and it just took a life of its own. Ms. Smith, you want to address the board and the inspectors?
Yes.
Yes, please.
Can you raise your right hand? Do you swear or affirm under the penalty of perjury that the answers that you give in the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes. I'd like to address the trash situation. I was a new neighbor, and when Baltimore City Trash came, they didn't pick mine up because they didn't think the business was open. So that's when we had trash, and Baltimore City comes like once a week. Since then, I talked to the Baltimore City Trash guys, and they take what they can. The trash that they don't take, I take away to the Baltimore City dump. So that's been cleared up. As far as the neighbor, Mr. David, before we called this incident, we had a mutual good thinking. We was good neighbors. I even helped him with he has a bread business. But I mean, I helped him, he's 70 years old, so I help him lift stuff and help him put some decorations up and stuff like that. So I thought we was pretty cordial, to the point that he can come over and say, hey, man, it's a little loud, turn it down. That's the report that I thought we had. But the incident that happened with my brother, I was emotional. So when they spoke to Mr. David, the agents, they was very polite, but I was honestly like, wasn't thinking. So that's the update.
Understandable. Go ahead. Okay, have you been back?
I haven't.
Who has this case?
I'd have. I was there during the day. It was quiet, no patrons at the time I was there.
Trash is taken care of and all?
Yes.
Okay. Anything further, Mr. Cass?
Nothing wrong to submit on that.
Questions?
No questions.
All right, thank you. On the basis of the materials contained in the charging documents, the proffer from counsel, including the admissions and the testimony received, I find a violation of Rule 3.082, sanitation and safety, on June 30, 2025, a violation of Rule 3.082, sanitation and safety, on July 8, 2025. 2025, violation of Rule 3.02A, cooperation, violation of Rule 3.12, general welfare, and a violation of 3.081D, sanitation and safety on July 18, 2025. I impose $50 fine as to each and give them 30 days to pay.
Yes, based on material and testimony provided, I also agree with the chair's findings of violation of Rule 3.082, sanitation safety with a fine of $50, violation of Rule 3.082, sanitation safety, fine of $50, violation of Rule 3.02A, cooperation, fine of $50, violation of Rule 3.12, general welfare, $50, and violation of Rule 3.081D, sanitation and safety, $50.
Based on the charging documents proffer made by counsel, admission made, testimony given today, I also find violation of Rule 3.082, sanitation and safety on June 30th, 2025. Violation of Rule 3.082, sanitation and safety, July 8th, 2025. Violation of Rule 3.02A, cooperation. Violation of Rule 3.12, general welfare, and a violation of Rule 3.081D, sanitation and safety, all on July 18, 2025. Also agree with the chair. $50 fine, 30 days to pay.
Mr. Russell.
I close exhibits for the record. Board exhibit number 1, violation report, Inspector Brown, 2 through 7, photos. 8, violation report, Agent Tudhope. 9, service request summary. Report dated 7/8/25. 10, violation report, Agent Perez. 11, 12, and 13, service request report dated 7/18/25, and 14, letter.
Thank you. Good luck, Mr. Smith.
Thank you for sending the letter.
Yes,
Thank you for sending the letter.
Final two cases are monetary penalty cases that had been, two cases that had been offered monetary penalties, and they requested hearings. First one is Michael Branch, Mike's LLC, trading as Mike's Bar Lounge, 6427 through 29 Harford Road, Class B beer, wine, and liquor license, violation of Rule 4.14, live entertainment without authorization on June 6, 2025, engaging in live entertainment outside without authorization, and violation of Rule 4.071, open containers in legal possession and consumption of alcoholic beverages on June 6, 2025, allowing persons to drink alcohol on the exterior of the property without permission. Please come forward.
Do we have service on Mr. Branch?
Yes, sir.
Okay, let's proceed.
Agent Tudhope, Baltimore City Liquor Board. On June 6, at approximately 9:50, myself and Agent Perez and members of the Social Club Task Force conducted an inspection at 6427 Harford Road at the establishment known as Mike's Bar Lounge. Upon arrival, we parked on Pinewood towards the rear of the establishment, where we could hear music coming from the establishment at an outdoor seating area. While waiting for the team to gather, a Mr. Michael Branch and the licensee and Miss Stacy McKenzie, my apologies, came to us outside and inquired why we were there. I informed that we were there for a inspection. Upon hearing this, Mr. Branch headed back inside the establishment, where I heard him inform the patrons in the outdoor seating area that they needed to head inside and take their drinks with them. I also observed Mr. Branch carrying 2 plastic cups past me and head inside through the rear door. I observed multiple people seated outside smoking hookah and drinking. Upon entering the establishment, I observed a DJ with a full setup with laptop microphone speakers performing. I conducted my full routine inspection, where I found that the establishment did not have outdoor seating or live entertainment on their liquor license. It should be noted that I had given them a previous written warning on 3/12/25 for having live entertainment. I issued the violations, and the task force left without further incident. And upon further investigation, I found that after I had given them the written warning, they were advertising for a DJ online. So that did not cease after that.
Commissioners have any questions?
No question.
No questions.
All right, thank you. On the basis then of the materials contained in the charging documents and the testimony received, I find a violation of Rule 4.14, live entertainment without authorization, and a violation of Rule 4.071, open containers, on June 6, 2025. As to the first violation, I impose a $500 fine. As to the second, a $250 fine, and I give them 30 days to pay.
350, Mr. Chair.
500 and 250.
250. Yes, based on materials and testimony provided, I also agree with the Chair's findings, violation of Rule 4.14, live entertainment without authorization with a fine of $500, violation of Rule 4.071, open containers and illegal possession and consumption of alcoholic beverages with a $250 fine.
Based on the charging documents and the testimony that was given today, I also find a violation of Rule 4.14, live entertainment without authorization, and a violation of Rule 4.071, open containers and illegal possession and consumption of alcoholic beverages, both on June 6, 2025, $500 fine for the first violation and $250 fine for the second violation, 30 days to pay.
Ms. Russell?
Icon exhibits for the record. Board Exhibit number 1, violation report, Agents Hut Hope, 2 through 8 photos.
Thank you.
Final case for the day. We're almost there. John W. Renner Jr., Non-Bar LLC, trading as Club Car 10-22 West North Avenue, Class BD7 beer, wine, and liquor license. Violation of Rule 4.071, open containers and legal possession and consumption of alcoholic beverages. On May 17, 2025, allowing patrons to drink alcohol in the exterior of the property without permission, and violation of Rule 3.02A, cooperation. On May 17, 2025, failing to produce a fire permit when requested to do so. Please come forward.
Well, good afternoon, unfortunately, Chairman and Commissioners. Stephen W. Fogel on behalf of licensee John Renner, who sent me an email I could share with the board at 11:33 this morning, indicating that Ryan Hasse can represent NAMBAR LLC. Ryan Hasse operates Club Car. He's the manager, and he wants him to represent here today.
That's fine. Admission or denial?
It is going to be denials, Your Honor. It'll be brief.
Okay, go ahead.
Agent Toto, Baltimore City Liquor Board. On May 17th, 2025, at approximately 12:11, while responding to a 311 complaint in the area, myself, Agent Perez, and Inspector Jordan observed a large group of approximately 20 to 30 people standing and seated at tables at the establishment known as Club Car, located at 10 to 22 North Ave. We observed multiple people drinking alcohol beverages outside, both seated and standing. Upon observing this and being aware that Agent Perez had previously given them a warning for having outdoor tables, we made contact with the manager and informed him of our findings. The manager removed the tables, instructed patrons not to exit the establishment with alcoholic beverages. Upon review of the licenses and permits of the establishment at that time could not provide us with a fire permit. I informed him that they would be receiving a violation, and we left the establishment without any further incident.
All right, thank you. Mr. Tuttle, you understand, it was explained to you why there were patrons out front, wasn't that right?
He stated that there was an event that just ended across the street, I believe.
Right. And you're aware that those people out front were not allowed into his establishment, right?
I was not aware.
Okay. And you mentioned that Agent Perez had previously warned them about outdoor tables. When was that warning given?
I believe that warning was issued back in November 2024.
All right, November 2024, they weren't even licensees then, Agent Perez. So how does that figure? They didn't get this license till January 22nd.
I wasn't aware that a licensee change was made. However, the gentleman standing to your right was the operator at that time.
Right, but they were going through their transfer at that time. So how would he have a fire permit if he wasn't even open?
We're speaking about the outdoor table service warning. I'm not speaking about the fire.
Right, but why would you even give a warning in November if they didn't pick up the license until January 22nd, 2025?
they were operating with a license on November 2024.
Okay. All right, thank you.
Anything else?
Yeah, I'm going to have to call my client to testify. And then we'll deal with we're dealing with both charges. So I'll go ahead and put him on now. If you could swear in Ryan Haase, Haase, first name Ryan, Ryan.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
I do. All right, thank you. You're Ryan Haase. You got to say yes. You got to be, yeah, verbal. Okay, and you're the general manager of Club Cod.
Yes, yes.
All right, and you run a club that serves cocktails in glasses, right? Okay, let's talk about.
Yes,
You got to be
do.
verbal.
Yeah, sorry about
Gotta
that.
be verbal.
Yeah, yeah.
Okay. And
He's leaving you. You could at least answer.
exactly. Try to.
1 year into being a bar owner, you know.
You got it. So look, May 17th, 2025. What was going on that night?
There was a film festival across the street at the Parkway. We hosted an after party for them. There was an insane amount of people. So we hit capacity pretty early on within our own space. And it wasn't until actually I was pulled outside because of them saying that there was like alcohol outside that we didn't even, I mean, there were blankets laid out. It was wild looking outside. And it really wasn't made to like, I did not understand how large the amount of people were
But this was a
outside.
DIY group. This was a do-it-yourself.
Yeah, and I can just say, like, for example,
No, to the microphone.
There's like other things, like in some of the photos, like on the table, like Jello shots. We don't do Jello shots. I mean, the beer in the bottom corner right there. We don't even sell that beer at the bar. So I will just say there was just like a lot of people bringing their own stuff and parking out front. When it comes to the tables, the tables, I thought the warning for the tables that we had was in 2025. I don't remember the November 2024 is what it is. But I will say, like, our location to a liquor store across the street, a park being right next to us, and then an after party across the street did cause it to be a scene out front. And then that's just regarding that. When it comes to like the fire permit,
We'll get into that in a minute. But I just want you to address, right?
And I will say the second it was brought to our attention that so many people were out front, my security came out and handled everything. But at the time, my security was inside.
But I mean, these folks out front, they were not welcomed by you, and they were not sold alcohol by you.
Correct.
Okay. All right, I have nothing further for this witness with respect to the 4.071 charge.
Let's proceed. We're going to get going.
All right. With respect to the fire permit, can you just give us a brief synopsis on your administrative hell trying to get a fire permit?
Yeah, we kept emailing, asking why we haven't received the fire permit. We had our use and occupancy, so we had our capacity. We had everything. This happened after the liquor license transfer in January. After a bunch of emails and me seeing a bunch of people who were in this room onto an email, we found out they were sending our license to 10 West North Avenue, and we are 12 West North Avenue. 10 West doesn't exist. Our license is 10 West through 22 West, but there's like no entrance at 10 West. It's kind of like the entrance is at 12 West. And so it wasn't until they actually brought by the actual copy, which I have here, they hand delivered it, and we have had the fire permit ever since.
All right, hang on one second. I'd like to introduce these emails between the fire department and the applicant, John Henner. And if you could just put one of those in evidence.
You're in evidence.
Thank you. And effectively, it explains that there's this massive address problem on this very block. And I want to throw into evidence an email I wrote to the liquor board on January 27th, 2025, regarding another place that was trying to pick up their license that week. And that was known as 10 to 30 West North Avenue. This place is known as 10 to 22 West North Avenue, meaning it's consumed by this other license, if you think of it that way. And I had to memorialize for the file the limitations I experienced during the transfer of the license on that same block. That block, the liquor board has known these places, and I guess the city has known these places as 10 to 22 West North and 10 to 30 West North for decades. That's what was on the old license. I think on the new license, they actually fixed it. But I had to send an email in to explain what the heck is going on that block. And what happened on that block was they never got their fire permit because of these address issues. It's a first-time licensee. It's a transfer that occurred on January 22nd of this year. So as far as the fire permit, which they have, and the only way they got it was because the fire department brought it directly to them because they stopped mailing it. It's been an administrative hell for them just to get your fire permit. So as far as we look at the fault on the licensee, is it non-cooperation? Absolutely not. Non-cooperation, as you know, is something that is a much higher bar. It's when you basically refuse to do something. I mean, I remember my favorite one was when Inspector Howard went and told the guy to turn the music down, and they did. And by the time Inspector Howard got back to his car, they turned it back up. Things like that. It's when you're really being defiant to an inspector. Non-cooperation, because you're going through this administrative snafu with old addresses, is not non-cooperation. They cooperated in every way. But if the fire department's not sending you your permit, you're not cooperating with the liquor board. You're just going through
the first time.
Administrative limbo. So if I could just put my email, it may explain some of the problems. I don't know what it is about that block.
What address do we have for this license now? We should probably make it 12.
Yeah. And I think that if you can read on there too in the email, John Renner, who is the actual, like the holder of the liquor license, he's our landlord, their actual address that they preferred isn't even 12 West. I think it's listed somewhere on there, and it's where they started the actual business entity, which, I mean, I don't have it in front of me, so I can't see, but it was John Renner requesting a different address as well.
All right. Anything further?
No, thank you. And look, what happened on the night of the after party, they make sure they keep their eyes peeled better on the outside, but they did not serve people. I mean, sometimes people just show up. And
we have since then not put any outdoor seating out. We've been really good about that. When we first moved in, we didn't know really what our limitations were there. We were on a block during art walks where people put out tables and chairs for the art walks. They do it to kind of make the neighborhood look nicer, so it was like an attempt to do that. But the second it became a bigger issue, we stopped putting out the seating.
All right, thank you.
Thank you. Commissioners have any questions?
So your security is coming outside, clearing the area?
Correct. And I mean, and now it's just like our security stays at the door, both not letting people bring in outdoor liquor, which happens, they like attempt often, and then vice versa, people trying to go out front as well.
No questions.
All right. Thank you. So on the basis of the materials contained in the charging documents and the testimony received, I would dismiss these violations.
You would dismiss both of them?
I would, yes.
Okay. Based on material and testimony provided, I also agree with the chair's findings of dismissal of violation of Rule 4.071 and also dismissal of violation of Rule 3.02A, cooperation.
Based on the charging documents proffered made by counsel and testimony that we received, I also agree with the chair to dismiss both violations.
Thank you.
Michael Exhibit for the record, Board Exhibit 1, violation report, Agent Tuttle, 2 through 4 photos, 5 email between licensee and fire department, and 6 email.
Thank you. Does that conclude our docket?
Yep. There being no further business for this board, the board is in recess until Thursday, October 9, 2025 at 10:30 a.m. We are adjourned.
Thank you.